The Honourable Susan Carter.
Thank you. I move private members business item number 3495 standing in my name. Portfolio Committee 5 handed down its report into identity protections for proceedings involving children on the 7th of July this year. In common with other committees, we faced problems obtaining all the relevant evidence we needed. The reasons are well known. Following the Cullen decision, we rely on the grace and favour of witnesses. And when the questions are hard and the answers uncomfortable, witnesses often decline to attend. This is a problem which impacts on our ability to perform our constitutional duties as a House of Review. But rather than cooperating with the rest of the House to address this problem, this government is resisting any attempts at redress. This is tantamount to attempting to change the New South Wales Constitution by stealth rather than the referendum process which is embedded therein. And it is impacting our ability to properly review the actions of the government and its agencies, which is perhaps exactly why the government is so comfortable with this change. Because review can be uncomfortable, but for a democratic society to work, it is essential. At times, it is tempting to see this as a deliberate government action to avoid review by this House. The Premier's chief advisor brought the legal action, the government paid for it, and the Minns government is refusing to respond to the invitation of the court to legislate to fix this problem. And as we found, it is a problem. A story about a young Aboriginal boy was leaked to a radio station. The radio station did nothing wrong. They carefully withheld the identity of the young offender. But they had been given his identity through a screenshot and more details of his time in court than would have appeared on that screenshot. Why is this an issue? Because we have taken a view as a society that young offenders should be given a second chance. Not infinite chances, but a second chance not to have offences committed as minors follow them for the rest of their lives, which is why there are strong prohibitions against revealing identities of young people appearing before the courts. But when this story was leaked, which through jigsaw identification could have tended to identify a boy in a country town, there was no reaction from government. No queries were raised as to whether this was appropriate or how this had happened. In evidence before the committee, it became clear that at a meeting attended by the DPP, her paid media consultant, an internal lawyer and an internal media advisor, a decision was workshopped to leak this story, down to the granular detail of to which media outlet the story should be leaked. The question of why this was in the public interest was never able to be answered. It was uncontested that it was reasonable for Ms Kaloran to believe that the discussion at this meeting authorised the leak. The focus of disciplinary action did not focus on the leak, but on a screenshot from an internal database that was handed over as corroboration of that leak. Ms Dowling claims she did not participate in this discussion, attended by her consultant being paid some $800 an hour, as she was distracted by her phone. We were unable to hear from the two others in attendance because of our ongoing witness issue. This inquiry raised important issues about protection of children's identities and about the use of confidential information by the ODPP, issues which we asked the Attorney-General to assist us in addressing more fully, using his powers of inquiry and compulsion. And how did the First Law Officer respond? Some 30 minutes after the report was tabled, he was offering derisory comments. So, did he read, digest and contemplate the 175-page report in that time frame before responding? Because surely he did not have access to the confidential committee report before that time. Or did he approach this issue with a closed mind? For the first time ever, the Attorney-General outsourced a response, briefing senior counsel at significant and undisclosed expense to the taxpayer, to read and reflect on the report for him. Without even the courtesy of a formal response, he has today declared the matter closed, despite the fact that the barrister who he paid to think for him was only asked to advise on some of the findings and none of the recommendations. We expect more of our Attorney-General. We expect him to show leadership when there are important questions of justice and important questions about protection of our young people and important questions that need answering. We expect him to restore public confidence in the role of the DPP and our criminal justice system, he should stand condemned by this House.